We are live. Thomas, can you hear me? Okay. Are we good? We're in the room? Okay, I'm going to start. Okay, sorry about that, everybody. Technical difficulties just getting in the room. I see we are a little late, so this is about an hour presentation. This should take us till about 12:15. Without further ado, let's begin. I believe everybody can see the slides I am seeing. So it should say estate planning crash course. And I'm going to be monitoring the chat as well. Okay. Here we go, just taking more and more people. All right. So good afternoon. My name is Joe Freed, and I'm an estates and trust attorney at Selzer Gervich. I work with folks to plan their affairs, which is what we are going to be speaking about today. I also practice estate administration and trust administration, which refers to the process of distributing a person's assets after a person passes away and complying with the relevant state and federal tax requirements and such. Our firm is located in Bethesda, Maryland. We service clients in Maryland, DC, and Virginia. Before I begin, I want to thank Steven Zeltzer for inviting me back to speak again. It's really always a pleasure for me to be able to collaborate with him in any way. Thank you to Thomas for handling all of the tech logistics for today's presentation and for bearing with me as I try and figure all of this out. Okay, and thank you for all of you letting me know that you can see the slides. And let's begin. One quick note before I begin. We've got a lot of ground to cover today. I've really thrown a lot of concepts into this presentation. I also know that there may be questions, and there should be questions. Having said that, I would hate to miss part of the presentation because I didn't get to it. So here's how we're going to do it. Whoever has a question can type it into the chat. I will try to monitor the chat as I speak. But as my wife will constantly remind me, I'm not a great multitasker. If there is a question which I feel will benefit everyone, and there are a lot of people on the chat, on the presentation today, I'll address it. But if I don't get to your question, it's not because it wasn't a very good question. It's simply because I want to stay on track. Nevertheless, if I didn't get to your question, you're more than welcome to reach out to me personally, and I will include my contact information at the end. My goal is that at about 12:15, approximately 12:15, when we end, each of you will be familiar with the concepts involved in estate planning, basic estate planning. Even if you may not be sure of all the details, you'll know the conversation to have, and you'll know the questions to raise to your attorney. So without further ado, let's begin. I'm just accepting more people here. And let's get this started. Estate planning can broadly fit into one or more of three purposes: protecting one's assets. We'll talk about what we're protecting the assets from, but sneak peek, tax and creditors are big ones. Preserving control over your financial and personal well-being, i.e. your money and your health. And three, your unique goals. Now, regarding those unique goals, before you sit down with your lawyer or you Zoom with your lawyer, let's be real, it's 2024. I typically meet the client in person for the first time at the signing, but you've got to determine what your goals are. Now, this is not some fluff slide I threw in for the heck of it. This is very important because meeting with your attorney will be so much smoother and so much more organized if you know what you're meeting about. My first question to every client is, what are your goals? And when the client answers, I don't know, my mom told me to call you and talk about getting a will, do you think I need one? Versus, I would like to talk about giving my assets away after I pass away, as well as who will care for me if I become incapacitated. That makes a world of a difference. It's a very different conversation. And to that second bullet point on the page, when I meet with clients, we discuss their assets in detail. I want to know every account they have, every life insurance policy, you name it. I want to know how it's titled. I want to know how much is in it, if there's a beneficiary, and so forth. So have all of this data ready when you meet with your attorney. Again, it will save you time and possibly an expense, not to mention the repercussions on your estate plan. I had a client who wanted to give everything to his 3 children equally. When I told him, just double check your life insurance policy, and he said, no, I know what it is. I said, just double check, humor me. He discovered that only the 2 older children were named as beneficiaries instead of all 3. So that would have thrown the whole estate plan off. So if you've learned nothing else today, at least remember to have your goals and assets set when you reach out to your lawyer. All right, today's topics. Methods of distribution of assets upon death, probate. I always feel like a Jeopardy host when I name these topics. Revocable trusts and irrevocable trusts, titling of assets, powers of attorney, estate and gift taxes, and finally estate planning documents that everyone should have. And excuse these brief pauses while I quickly try and monitor the chat. Okay. So our first method of distributing the assets upon death. When a person passes away, there are different rules, we'll call them methods, for distributing their assets. There is intestacy, which refers to a situation where a person died without a will. There's a will. There's joint ownership, such as when there are multiple individuals on an asset's deed or title or statement, account statement, and designation of beneficiaries. We will discuss and compare each of these. Our first method, for lack of a better term, is called intestacy. When a person passes away without a will, there's a common misconception that his assets all go to the state. You'll be very relieved to hear that this is not the case. Instead, each state, and I'm in Maryland, so I'll use Maryland as an example, but this applies to every state, has a set of statutes which act as a default will for a person and direct where a person's assets must go and in what proportions they must be divided. These are known as intestacy statutes. Passing away without a will is called passing away intestate, and with a will is called testate. The provisions which dispose of the assets in these statutes are called dispositive provisions. Now, there are differences between whether the person who passed away, and by the way, the term for the person who passed away is the decedent. There are differences of whether the decedent was married or single. We'll take a closer look at the dispositive provisions so you can see how states approach a situation where a person died with assets. And remember, everyone has something. Everyone has some asset. And when the decedent provided no legal instrument indicating her desires for where the assets should go. So if the decedent died unmarried, so there's no surviving spouse, the assets are divided among the decedent's children. Again, this is Maryland, but other states are very similar. And every state has something. What if he had no children? So you go up the family tree to descendants of his parents. Does he have siblings? Now, if those siblings passed away, did those siblings have children? What if they're no descendants of the decedent's parents? There's no living siblings, and those siblings don't have any children or grandchildren. You go up again to descendants of the decedent's grandparents. Does the decedent, remember the person who passed away, have cousins? Did those cousins have children? And so on and so forth. You could see where this is going and how complicated it can quickly become. Now, interestingly, different states end at different points. So Maryland ends with the grandparents, the descendants of the grandparents, right? Although a couple of years ago, they went up to great-grandparents. So it's very interesting how different states end at different times. We've all had the dream of getting that call from a lawyer saying, you've received an inheritance from some unknown relative, but that's not always the case, and it's not always so grand. I've had to make that call before, and it usually sounds something like, hello, my name is Joe Freed, and I'm an attorney. I'm letting you know you've inherited 1/24th of an interest in a home that has a mortgage and needs repairs and is in a state at the other end of the country. So it's not as fun to deal with, and should be avoided at all costs. Next slide here. All right. So how does the state approach this problem? And the intestacy statutes in Maryland recently changed. So here are the updated formulas. The first slide shows the formula for a situation where the decedent, remember the person who passed away, had a surviving spouse. Half of the assets go to the surviving spouse, and half of the assets are divided among the minor children. Let's think about that for a moment. Most people who have a spouse, and say a 7-year-old and a 4-year-old, would not leave anything directly to the 7 and 4-year-old, right? Let's say a person has $200,000. That means the spouse, the surviving spouse, gets $100,000, and the other two children each get $50,000. We'll talk about how children can inherit in a moment, but you're starting to see some of the issues and the pitfalls of intestacy. So next, if there are adult children that are only children of the decedent and not the surviving spouse, right? Let's call it a second marriage or whatever. The surviving spouse receives $100,000 off the top, and then half of the remainder of the assets after that $100,000. And then the adult children divide the remaining half of the assets, okay? Third situation, if there are adult children that are children of both of the decedent and the surviving spouse, those children receive nothing, and the surviving spouse receives everything. So let's take a moment to talk about how minor children inherit assets at all. In order for a minor child to use their inherited assets, there needs to be either, one, a guardianship. This is a court-supervised situation. There are accountings. It's very annoying, and it's burdensome and should be avoided. There's also a custodianship, which is a unique bank account held by a custodian for a minor. It's less annoying than a guardianship, but not necessarily ideal in all situations. The third way is a trust account, and we'll talk about this later in far greater detail, but these are generally more beneficial. But don't forget where we're at here in our calculation. In the intestacy situation that we're talking about, there is no trust. There's no custodianship, so it's got to be a guardianship. I don't know if I mentioned this, but it's very annoying and should be avoided. Okay. So you're starting to see some of the drawbacks to intestacy, to these default statutes for when a decedent died without a will. Now, here's a whole list of them. And I realize that this slide is kind of jam-packed. We tried to avoid that, but we'll take each point as we go. You don't, number one, you don't get to say where your assets go, right? Very obvious drawback. Maybe you want your spouse to get everything, or maybe not. But you don't get to choose. As we said, if you have children in certain situations, the surviving spouse does not get 100% of the assets. It could be a large percentage goes to the children. Now, this is very interesting. We already discussed how minor children inherit, but say they've passed that stage. Let's say that they're adults, they've turned 18. The problem is they inherit everything at 18, as in all of the assets left in the account, they get it in one shot when they turn 18. With some custodianships, it could be 21, but the norm is 18. Now, frankly, 21 might be a problem as well, because I don't know what you were like at 18, but if I inherited assets at 18 years old, trust me, the assets would not have lasted. Even at 21, when I was in college, if I inherited assets, that would have been, let's say, one heck of a toga party. Now you'll say, not my kid, he's mature, she's very fiscally savvy, she's responsible. And to that I will say that the psychological response to inheriting money is very similar to one who wins the lottery. How so? Because the person receiving the money never worked for it and never developed that almost emotional bond, if you will, to each dollar. We all know that the surprising and frightening statistics of lottery winners and how quickly they can go bankrupt. And it's astounding. So when a person inherits $200,000, for example, outright in one shot, maybe they won't go to Vegas. But whereas they may have purchased a new $25,000 car, now they may say, no, well, I think I'll get that $70,000 car instead. And you as the testator, or if you're the intestate, the intestate decedent, we'll call you, you may not want your money going towards that $70,000 car. That's something to consider. Now, the next point may be the most important point I make the entire day. So if you haven't heard anything and you're not planning on hearing anything, just listen to this one idea. And this is what I tell any parents with minor or disabled children. If you don't designate someone in your will who should be the guardian of your children, for your children, the court will decide who should do it. To be accurate, at least in Maryland, the court always decides. But the point is, and the standard they use is the best interest of the child. But when the court sees that the parents designated someone specifically in their will, that's a very heavily weighted factor that the court considers. So every parent's got to have a will, we'll talk about that, where they designate the guardians for their minor and or disabled children. We'll talk about the estate tax planning and creditor protection, Medicaid and trusts in more detail. I don't want to get bogged down now, but just know that a person who passes away without a will has none of those benefits. Take a moment to check chat here. Okay. Onward. So we talked about a situation without a will, right? How the decedent's assets are distributed according to intestacy. And a number of drawbacks to not having a will. Now, let's talk about wills. First off, how do you make one? Well, according to the statute, and again, though this is Maryland, most states have similar statutes, anyone 18 or older, an adult, can make a will. A will needs to be in writing, signed by 2 adult witnesses. So if I leave my friend a voice note, right, not in writing, a WhatsApp voice note, and I say, hey, if I die on my fishing trip I'm going on tomorrow, you can totally keep my fishing rods. Is that a valid will? Well, it would make for an interesting law school exam question, but I wouldn't recommend this method. There are also additional formalities. For example, the witnesses must sign in front of the testator. The testator is the person making the will. This is a very important point. There are these formalities, and they really matter. So be very careful who you work with. Make sure you know what you're doing. If a person does a will online, for example, and does it himself, there is a good chance the will won't be valid because of these additional formalities. Case in point, I was working on a case a few years back, and the testator, again, the person making the will, was sitting in the kitchen. Okay, so picture this: he's sitting in the kitchen. It was a small, cramped kitchen, And the witnesses, I think one of the witnesses said, I want to write neatly. There's not a lot of room. Let me take the document, this will, to the adjoining dining room and just sign on that table. So kitchen over here, dining room over here. But the way the house was set up, you couldn't see the dining room. It was out of the line of sight from the kitchen table. It was just around the corner. That was not a valid will. And it didn't have a happy ending. The repercussions for the kids were not pleasant. So these formalities matter. So make sure you work with someone who knows what they're doing. Okay, just checking the slides quickly. So the benefits of having a will are readily apparent. You can say who gets your stuff, simple as that. Parents, you can designate guardians for your minor and or disabled children. Again, the court will ultimately decide, but your designation is a very heavily weighted factor. We will get into trusts later, but for these next 2 points, just know that you can have a will that creates a trust from the will, okay? Again, we're talking about trust soon. With these trusts in the will, you can protect your children's inheritance from divorce or creditors. If a person receives it all outright at 18, then gets married, then gets divorced, those assets may be marital property and subject to a divorce settlement. Also, a person may have creditors. And if a person receives everything outright, the assets are subject to those creditors. The creditors can reach that money. Now, I don't care how clean your record is now or how great your credit is, and I don't want to scare anyone, but one lane change without signaling, and you can have a motorcyclist as a creditor, right? A person accidentally hits a school bus, and suddenly they've got 50 sets of parents that are creditors. So plan now to make sure they can't reach all of your assets. Then there's estate tax. Again, we'll talk about estate tax more later, and I won't go into such detail now because, frankly, it's really not a problem for most folks. If a person dies with enough assets, though, they could wind up paying what's known as estate tax. So we'll talk about this later, but just know that there are certain methods for planning around this that you cannot achieve through intestacy. The last point on the slide, and it's a little cut off at the bottom, is appointing a PR. A PR stands for personal representative. Personal representative, which is also known as an executor. In Maryland, we say personal representative. That's the person in charge of distributing your estate after you pass away. Okay, they will have to file certain documents with the Register of Wills, which is, at least in Maryland, that's what it's called, the state government body that has oversight over this process. This process is called probate. Again, we will deal with probate later. So in your will, you designate the person whom you trust to wind up your affairs after you pass away. Now, similar to intestacy, if you don't designate a PR in your will, there are default statutes with an order of priority who can serve in this role, for people who can serve in this role. We will talk about probate on a later slide. Now, the PR is somebody who has a certain amount of discretion. So even though you've said, I want my fishing rods going to John, I want this plant going to Nancy, in certain cases, and in most cases, they're faced, for example, with the question of, okay, this person said $5,000 to Nancy. Can I sell this asset to make up that money? Or maybe it's fishing rods, the actual fishing rods. There are certain discretionary decisions that the PR has to make. So this is someone you should think about and you should trust before you appoint this person in the role. All right. So far, we've discussed intestacy, when a person dies without a will. And we've discussed wills, a document where a person designates certain assets to go to certain people and can be used to appoint guardians for minor and disabled children and where the decedent appoints the PR, the personal representative. A third method of distributing one's assets after passing away is by owning those assets as a joint owner. When owned as a joint owner in certain ways, the surviving joint owner generally takes ownership of the deceased person's portion upon their death. I see the formatting isn't great on this slide, so my apologies for that. But there are three ways of jointly owning something. Number one, what's known as JTWROS, joint tenants with rights of survivorship. Number two, tenants by the entirety. And number three, TIC, tenants in common. The first way, joint tenants with rights of survivorship, two or more people own something. Well, let's keep it simple and say two people own it, okay? When one person dies, the other person gets it. Simple as that. Well, like everything, there are pros and cons. All right, the pros, it passes very easily to the other person. It avoids probate. It doesn't have to go through a will or a trust. So that's all great. But by the same token, you really have to make sure you've thought it through when you decided to take ownership of a certain asset with this other person, because if that relationship changes and you wish you could have disposed of this asset through your will and pass it to somebody else, that can't happen. This ownership method overrides a will designation. So you have to be very careful who you choose. Finally, there's no creditor protection. By that I mean the creditor can foreclose on your interest. You're jointly liable for each other's debts and liabilities for this asset, for this account. We will talk about this in a later slide as well. The second way of jointly owning something is called tenants by the entirety, T by E. This is the same as joint tenants with rights of survivorship that we just spoke about, except that this only applies to a married couple. But there's one key difference. Here, there's strong creditor protection. That is, even if one spouse decided to go to Vegas and put up the family home as collateral, creditors cannot take that home in most cases because it belongs to the other spouse. At least in Maryland, this is well settled law. So generally, when you have a chance to title something as tenants by the entirety, of course, you should speak to a lawyer about the details, but generally, this is a very strong way of titling an asset. Just give me one moment. The third way is called tenants in common. Now, this is interesting. Here, you own a percentage of your home without any joint interest. So let's say 4 siblings own a home as tenants in common. Whereas by joint tenants with rights of survivorship, each sibling owned 100% interest. And by tenants by the entirety, each spouse owned 100%. By tenants in common, each sibling in this case would own 25%. And when one sibling passes away, the other siblings do not automatically take the deceased sibling's share. Rather, the deceased sibling's share passes according to the way she left it in her will, or if she had no will, then intestacy. So these are 3 methods, 3 ways of owning an asset jointly titled, and we've talked about how and if they pass to a surviving party or if they pass in the will. By joint tenants with rights of survivorship and tenants by the entirety, they pass to the joint owner. And by tenants in common, they pass according to a person's will or intestacy. Okay. The final method for distributing assets upon death is by having a designated beneficiary. And again, for the people whose questions I haven't addressed, I encourage you to reach out to me, but we're kind of short on time and I don't want to get sidetracked. they are great questions, so please reach out to me, and I'm looking forward to explaining it to you. The final method, as we said, is a designated beneficiary. So this applies to certain kinds of accounts that have beneficiary forms. For example, a brokerage account has a TO, a transfer on death form, and a regular bank account has a POD, a payable on death form, essentially the same thing. It also applies to trusts, which we'll talk about in a few minutes, which have beneficiaries. So this is a very smooth method of transferring assets, this designated beneficiary. It does avoid probate, which is our next slide. We're getting there. You just have to make sure that it's updated according to the rest of your estate plan, right? Like I mentioned earlier, I had a client who completely forgot about his life insurance beneficiary designations, and it almost messed up his entire estate plan. You should also make sure to speak to an attorney that knows what they're talking about, because, and I'll mention this briefly because it's definitely beyond the scope of our discussion, but the Secure Act 2.0 of 2022, so certain retirement beneficiaries have a shorter period than others to withdraw the retirement funds. That's all I'll say on that for the moment, but just know that is out there and it is a consideration. So we've mentioned it a number of times today. So without further ado, probate. Probate is the court-supervised process of disposing of individually titled assets upon your death. Whether or not a person has a will, there is probate. Now again, this only applies to assets you own alone in your name without any designated beneficiaries or joint owners. So why do us estate planning attorneys always talk about avoiding probate? Well, here are some problems with probate. First off, it's public. That is, when we submit documents to the Register of Wills, such as the will itself, a list of all probate assets, right, all of the values, accountings of where the assets went, this is all public. That's right. You can search your next door neighbor's probate documents if you want. Not sure why you would want to, but you can. Now, a lot of folks want to avoid this for obvious reasons. They would rather it be private. Also, let's say you're trying to sell a business and maybe you don't want potential buyers to see how everything's evaluated. This could be an issue as well. So that's issue number one. A second issue with probate, and no offense to all of you, but let's be frank, you know this as well as anyone, dealing with the government is not always a walk in the park. Sorry, I had to say it. This process isn't completed overnight. A regular estate in Maryland can take anywhere from, say, 6.5, 7 months to a few years in certain cases. And Maryland is not nearly as bad as other states, okay? You know who you are, California. Let's say someone lived in Maryland, and let's say they had a cottage in Vermont and a condo in Florida, right? You've got to do probate in Maryland, open up ancillary probate proceedings in Vermont and in Florida. You've got 3 probate estates open. There is also an expense associated with probate, right? Besides for the Register of Wills fee itself, which can be anywhere from a couple of hundred to thousands of dollars, depending on the size of the estate. So you'll likely have to hire an attorney, and the list of expenses can go on. And of course, those pesky creditors. With probate, you have to publish notice in a newspaper that the estate is open and that creditors have a certain amount of time to make a claim. And there's no creditor protection for your beneficiaries, as there may be for a trust, which we will get to in a moment. So we've outlined the pitfalls of probate. Now, how do we avoid it? There are a few different ways, but I'll say right off the bat that not each way works or is ideal for everyone. I will say that you can be so focused on avoiding probate that you choose a method which ultimately gives you more risk than reward. The general idea is to not have assets titled in your name alone. So we've already discussed different ways of titling assets, joint tenants with rights of survivorship, or tenants by the entirety. But again, joint tenants with rights of survivorship has risks associated with it that we outlined on the previous slide. So unless you've got someone not only that you trust, but someone who is a fiscally good investment, it may not be worth trying to avoid probate. By the way, these are the kinds of discussions you should be having with your attorney. There are also TO, transfer on death, and payable on death accounts. But again, there's no creditor protection there. And of course, designated beneficiary forms, which work. So finally, at long last, we've got the trust. All right. Here we go. Okay. I want you to picture a jar. Okay? Make it a glass jar. I should have included this picture on my slide. So picture a glass jar. Now picture yourself taking a toy car and putting it in the glass jar. Okay? And now picture yourself taking a toy house, putting it in the jar. Okay? Sprinkle some Monopoly money in there as well. That's a trust. A trust is a jar. It's a legal entity in which you place your assets, your car, your house, your money, etc. A trust that you create during your lifetime and place your assets into when you reserve the right to revoke at some point during your lifetime or modify the terms, that's called a revocable living trust, as the name suggests. A revocable trust is a will substitute in that you name the beneficiaries of your estate. In other words, you say who gets your stuff, simply put. And also, it doesn't just kick in when you pass away, as a will does, but you can actually manage assets in the trust during your lifetime. Now, one thing I want to make very clear, and I would shout this out from the rooftops because there's a lot of misconception out there. I think I already said if you take one thing out of this presentation, take something, but if you take a second thing out of this presentation, take this. We'll talk about creditor protection in a moment, but you, the person creating the trust and putting assets into the revocable trust, do not have creditor protection, okay? You cannot put assets into a revocable living trust and protect those assets from your creditors. Okay. Not sure why that slide has that cross out. All right. So we talked about our glass jar. We talked about that trust, but let's get some terms straight. The way the jar is created is by signing an agreement, a trust agreement. An agreement between whom? Well, between the person creating the trust, called the grantor. Some jurisdictions say settlor or trustor. That's all the same person, all the same role. We'll just say grantor. Now, who gets to reach their hands into the jar and give stuff out? That's the trustee. So the agreement is between the grantor and the trustee. That's how the trust is created. Now, who does the trustee give the assets to? Well, that's the beneficiary or beneficiaries. Interestingly, they can all be the same person. As the slides say, the grantor is Ben, the trustee is Ben, and the beneficiary is Ben. Of course, these could also be different people as well. All of these jobs are written in the trust agreement, right? We'll say, let's say, pretend they're different people. Ben is the grantor, Nancy's the trustee, and Bill is the beneficiary. Now, there are provisions in the trust agreement that address two broad scenarios: while the grantor is alive and after the grantor dies. So how do assets, your house, for example, get placed into the jar? The answer is by retitling them in the name of the trust. So we we'll create that trust, we'll create the jar, and then I'll draft a deed. The deed will say, Ben and Sally Smith currently own this property, this house, as tenants by the entirety, and they give their house to the trustees of their trusts to be held in trust. Voila, the house is now in the trust, it's in the jar. Your bank account says Ben Smith. After we draft the trust, you'll work with the bank, you'll retitle the bank account to say Ben Smith, trustee of the Ben Smith Revocable Trust. Voila, your bank account is now in the trust, all that monopoly money. But you gotta remember to retitle the assets. I can't tell you how many times I've seen a beautifully drafted trust, everything's ready to go, and the client just forgets to retitle their assets and actually put things in the trust. Or they do a few assets and forget some. And in that case, at least the assets that made it into the trust have all the benefits of the trust, but they haven't necessarily avoided probate from the assets that didn't make it into the trust. So now you've made your revocable trust, but the income tax still flows through you individually. So you'll have to report any income generated through your rev trust, through your revocable trust, on your 1040, right, on your personal income tax return. So as we mentioned, putting your stuff into the trust doesn't help with creditors. It doesn't help with estate tax either. At death, though, a trust gives a lot more control than a will. With a will, everything's given outright. So that is, you've got a bank account with $100,000 that you give your son. So in a will, he gets the full $100,000 in one shot when you pass away. That's how it works with a will. But with a trust, you can structure how and when and under what conditions your stuff is given out. You can say, I want this given out by the trustee to my son for his health, his education, his maintenance, and his support. And that's not given in one shot. The trustee could use it to pay for your son's wedding or purchasing his first home or schooling, etc. The point is you could preserve the assets and distribute them a lot more carefully. Another cool thing about the way is the way it avoids probate. So remember the case where that decedent lived in Maryland and had that Vermont cottage and Florida condo, and he had to open up 3 probate estates? Well, with a trust, he simply puts each of those properties into his trust, and voila, no probate necessary in any state. So to sum it all up, with a trust, since there's no probate, everything's private, there's no public record, there are a lot of obvious benefits here. Try to get to the next slide. Hang on, I might be freezing. Okay, I think I was frozen for a minute. I don't know if all of you can hear me. Trying to pull up the chat, but I'm frozen. Here we go. If you can hear me and see me, can you just let me know in the chat? Because from my end, I am frozen. Okay, You guys can see me. Irrevocable trust. Okay, so we will continue. We will continue. Sorry for the tech difficulties here. Okay. Until now, we've been talking about one kind of trust, right? A revocable trust, where the grantor, again, that's the person creating the trust, reserves the power in the trust agreement to revoke or to amend or modify the terms of the trust during his lifetime. There's another kind of trust called an irrevocable trust. This trust, as the name so aptly describes, cannot be revoked by the grantor. With this kind of jar, right, the grantor puts his assets in the jar for someone else, then puts a lid on that jar, and he can't take that lid off. He can't revoke anything. So why would anyone choose to make a trust that they cannot revoke? Right? We know there's a trust that they could revoke and change. So why would you choose this one where you can't do anything? You can't change it. Once it's in there, it's in. The answer is because there's additional benefits to an irrevocable trust that a revocable trust does not have. Essentially, when a person uses this trust, they are giving the assets now. It's not in their name anymore. When this happens, there are certain benefits. You can leave it in trust to a minor child, for example, and it's locked in there. You can't take it out, so it's safe. And when the time comes, the trustee can distribute it. There's also creditor protection, divorce asset protection, all of the issues we raised previously. This trust prevents. Of course, the big drawback is it's not yours anymore. You can't use it. So you better be very careful that when you put something in this trust, you don't need it anymore. So that's what we'll say on trusts today. The last note I will make is that, yes, everyone can clearly see how beneficial trusts can be in so many different ways. But trusts are not for everyone. Some lawyers will go straight for revocable trusts, but trusts are more expensive to set up front. There's no bright line rule for how many assets a person should have, how much a person's assets should total in order to create a revocable trust. But for example, I met with a client last week whose only probate assets, right, the only assets he had titled in his own name without any designated beneficiaries, were a house and one bank account. So I recommended a will. Again, it's his choice, but it's less expensive up front, and it would serve his purposes. The example I like to use for using a trust when you don't necessarily have the assets for it, it's like having an 18-wheel truck deliver a pie of pizza. It would work, but it would be unnecessarily bulky. And the benefits wouldn't necessarily outweigh the expense. Okay, let's try to switch the next slide here. My computer is giving me a very hard time here, but my next slide should be talking about asset titling. Wait a moment. While I am waiting for this next slide to load, I can quickly check on the chat. I'm sorry this is taking so long. I'm not quite sure why this system is not working. Okay, let's see. Is it loading for you guys? Sorry, this is taking so long here. Okay. Okay, that is working a little bit better for me. Sorry for the delay there, but if you can kindly let me know if you're looking at the slide titled Asset Titling, that's what I'm looking at. Okay. Okay, I'm going to start from the beginning of asset titling. There's a lag between audio when I speak. Okay, I'll try turning off my video. Okay, you can see asset titling, and it sounds like you can hear me, so sorry about these tech issues. Let's start from where we're at, asset titling. If we go a little over, we'll go a little over. Everyone's going to get the recording, so you could speed this part up on the recording. All right, onward. To reiterate a point that I find folks often need clarity on, and that is asset titling. So specifically, when an asset's title, deed, or account statement, what it says. So this affects the access to the asset and the use of the asset during the owner's lifetime. There are pros and cons. Okay, so for example, a mother adds a daughter's name to the mother's bank account as a joint owner with rights of survivorship, right? So if the mother does this, both the mother and daughter have legal access to the account. That is, even if the daughter did not contribute 1 penny. When mom dies, daughter has full ownership, even if the mother intended other siblings to benefit. Or for the account to go to somebody else, right? So here's the rule. The titling of the asset overrides a person's will. So even if the mother only had this one account, right? When she wrote in her will that I wanted this account to be divided among my 3 children, but then she has only one of those children as a joint owner, only that one child gets that account after mom passes away. So this is a real issue for a lot of people who don't realize this. Additionally, now that the account is in both mom and daughter's name, the account is susceptible, this is a big point, to both mom's creditors and daughter's creditors. Again, even if daughter contributed nothing to this account, her creditors can still reach the account. So a really unfortunate situation can occur. Mom works her whole life and she saves everything in this one account. Then she adds daughter because she needs help managing the account. Daughter makes a left-hand turn without signaling. Suddenly, the entire account is depleted by the daughter's creditors, even though daughter didn't contribute 1 penny to the account. Now, does this arrangement avoid probate? Yes. Is it the simplest way of passing assets after death? Pretty much, yeah. But are there risks involved? You bet. I'm not trying to talk anyone out of doing this. I'm just trying to make you aware of the pros and cons so that you can make an educated decision. Next slide, asset titling. And I'm just saying that out loud to make sure everybody's with me. Yes, you can do, I see Tanya's, you can do a payable on death to your children, but the issue with that is it depends on the institution whether or not they allow the payable on death individual to have access, and that's really exactly the slide I'm talking about now. That's a great point. What you might consider doing instead is to add someone's name, let's say the daughter's name, to the account, not as a joint owner, but as a convenience individual. You can make a convenience account wherein you designate someone to assist with depositing and withdrawing money. This account doesn't change ownership, right? So mother still owns it entirely, and therefore it will be part of the mother's estate, and it will be subject to probate, but you avoid the risk of it being susceptible to the daughter's creditors. Plus, now it's subject to the terms of the mother's will, so it can be easier to plan for. Of course, we've talked about this, but I'll mention it once again. The benefits of titling for married couples as tenants by the entirety should always be considered if possible. And finally, for those of you who make a trust or who perhaps already have a trust, you must remember to retitle the assets that you want to place in the trust in the name of the trust. Otherwise, you've created the jar without putting anything inside of it. Okay, I see the hour is late, and I apologize for the delays. We've got a few more minutes here. I'm going to try to get through everything as quickly and efficiently as possible. We've got three more substantive slides, so hang tight. Now we are completely changing gears. Until now, we've spoken about a method of distribution after death. We've talked about probate, revocable and irrevocable trusts, and titling of assets. The common factor between all of those topics is they focus on after a person passes away primarily. Now we're going to talk about planning for when a person is still alive but incapacitated. And I'm going to speak in blunt terms because I find that people understand real life situations better than lofty legal concepts. I want you to think for a moment about the following. What happens if you're driving tomorrow, you have an accident, and you're laying in the hospital, unable to move or speak or function? I have two questions for you. One, who is going to take care of your bills? Who's going to pay taxes that are coming up? And I'm sure everyone's very happy that I reminded you about that. Who is going to pay your utilities, right? Your mortgage, anything else? That's question number one. Question number two, you're laying there unable to speak or move. Maybe you're not conscious. The doctor wants to perform a certain procedure, but you're not able to ask any questions or consent to it or decline it. What happens? We plan for this. We draft what are known as powers of attorney. We draft a financial power of attorney and a medical power of attorney. Power of attorney has you, the person making it, called the principal, appoint someone to act on your behalf. That person acting for you is called the agent, or the attorney in fact, if you should become incapacitated. So let's get some terms straight. A durable power of attorney is a power of attorney that you draft today, appointing someone as your agent. Technically, it applies right away, and of course, when a person becomes incapacitated as well. A springing power of attorney only takes effect when certain situations and when certain conditions have happened, such as you're becoming incapacitated. So I'm sure everybody's thinking, I'll do the springing power of attorney. Why not? Why do I need this to take effect now? The answer is, again, I'm not telling anyone what to do. I'm only outlining the pros and cons. Oftentimes, in an emergency situation, you need the power of attorney to happen immediately. A person has a bill that's due, or a doctor needs to know whether to perform a procedure now. So you don't have time to get two medical opinions stating that you, the principal, are incapacitated, and to get everyone on board and agree that this has taken effect. You need quick action. Maryland has a statutory power of attorney, as do, I believe, most states, and the statute says exactly what it should say. Our firm, and I think most firms, have a separate document which can supplement the statutory power of attorney and add additional powers. Now, warning, and I don't know if I've said this before, but if you take anything out of this seminar, this is the third thing you should take out. Financial powers of attorney are very powerful documents and should not be taken lightly. The person you choose as agent will have access to your bank accounts and all assets. When I asked a client recently who he chose as his agent, he said, I don't know, maybe my neighbor. I explained to him that I don't know your relationship with you, what it's like with your neighbor. Maybe it's great and this could be a good idea, but be very, very cautious whom you choose. Now, something to be aware of, sometimes a limited power of attorney can work as well. A limited power of attorney is a document in which you appoint an agent for one specific transaction. So for example, let's say a father has agreed to co-sign a mortgage for his daughter's first home. Problem is the father lives in Denver and daughter lives, say, here in Baltimore. Father cannot be present at the signing. He lives far away. He can't travel for it. So father can appoint someone else, someone he knows and trusts in Baltimore, let's say his son, to sign on his behalf. Now, son cannot take that limited power of attorney to the bank and withdraw funds from his father's account. It only works for this one transaction. In fact, I had a colleague of mine who once went abroad for a few months and needed someone to drive his car while he was away. I agreed. And he drafted a limited power of attorney for me, showing that I had the authority to drive his car. Now, the medical power of attorney here in Maryland is called the advance directive, has two parts. The appointment of a healthcare agent, like we spoke about, and also a living will, where you make the end-of-life decisions now while you have the capacity to do so. This makes those unfortunate, very difficult end-of-life decisions a little bit easier for your loved ones. I shouldn't say easier, but they have a lot less guilt when they have to make a decision, but they know you've made this decision first. So what happens if you don't have any of this stuff? What happens if you're laying in the hospital, you have not appointed an agent, you have not executed a power of attorney? So the court would need to appoint a guardian. This is similar to appointing a guardian for a minor child, as we spoke about, but here it's for an incapacitated adult. There are two types of guardians. A guardian of the person. This is the person who takes care of your day-to-day, where you live, what you eat, where you go, etc. And a guardian of the property. This is someone who manages your money. I don't know if I mentioned this already, but guardianships are very annoying. They're burdensome and should be avoided. Finally, the last thing on this slide, there are HIPAA authorizations. Because of HIPAA, even a family member cannot just walk into the hospital and have access to your medical records. This could be very difficult for family members who desperately want to know what's going on but are refused access. So we draft these authorization forms to allow certain people that you list on the form to have access to you and to your medical records. They cannot make decisions, right? That's the advance directive, but they can have access. They can be allowed to know what is going on. Okay, moving right along here. Did I skip a line? No, here we are. Okay. Current estate and gift tax laws. I will go through this very quickly. This is the last substantive slide. And this slide probably won't affect most of you, but you can't have a crash course in estate planning without mentioning these basic tax concepts. Estate tax is the tax that your estate has to pay from your assets when you pass away. The rate is 40%. You heard that, 40%. But there's a massive exemption, okay? There's a federal exemption of $13,610,000. This means that you can shelter that much money before having to pay anything. For married couples, that's doubled to $27,220,000. As I said, estate tax is not going to be a problem for most people. And if it's a problem for you, I would love to get your contact information. Note, though, that this is subject to sunset to $5 million in 2026. Still not a problem for most folks. What's really neat is that you can share your unused exemption with your surviving spouse through what is known as portability. There's no distinction here between probate and non-probate assets. So whatever a person owns, even if he put it into a revocable trust in his lifetime, this is subject to this tax. Not all states have estate tax, but Maryland does, DC does. Maryland is a $5 million exemption, and you can see that the rates fluctuate, as does DC. finally, the very last substantive point I'll make for this webinar, there is a gift tax. Now, people get very confused about this gift tax. So I'm going to try to get it a lot more clear here. A gift tax is on the person gifting the money, not on the person receiving it. If you give over a certain amount of money, you have to pay tax on that gift. But hold on, just like each person has that $13 million estate tax exemption, they also use that same exemption for gift tax. So a person can gift up to $13,610,000 without having to pay any tax. If, however, they exceed $18,000 or $36,000 for couples, they need to keep track, not paying tax. They're keeping track of that gift by filing a gift tax return. Again, they're not paying tax on it. So let's say a person gives $100,000. So as long as they have their unused exemption amount, so they don't have to file, they don't have to pay tax, but they have to file a Form 709, a gift tax return, just to let the government know that they made this gift and it should be subtracted from their exemption amount. Now, interestingly, and very good to know, you can give $18,000 as many times as you want to as many individuals as you want, and you don't have to file a 709. It's only when you give one person an amount in excess of $18,000 that you file the 709. Okay, I'm just putting my camera on for this. That is pretty much it. Here are the documents that everyone should have, okay? A will, possibly a revocable trust, beneficiary designation forms for retirement accounts and life insurance policies, durable financial power of attorney, and advanced medical directives. We've talked about the living will, and we talked about HIPAA. I just see one comment. A POA never expires unless you put timing on it. Yes, power of attorney will expire upon death. So just know that that terminates upon death. Okay. How often do you need to do power of attorney? Yes, a power of attorney could still be, unless, just like David pointed out, unless you place a termination term on it, it's still good today, but it's a good idea to update it for new statutory language. Okay, so we've compiled this, what we'll call a cheat sheet, and anyone who uses this QR code, or we've got a link here, can download that sheet. It'll be emailed to them. I hope everyone gained something from this presentation. I spoke quickly, and I covered a lot of ground, and I'm sorry for any tech glitches that occurred. But hopefully, in this past hour, you learned about some of these concepts. And like I said at the beginning, you can at least ask the right questions now, as many of you are doing in the chat. For those of you who have questions that I didn't get to, or that may occur to you after we hang up here, don't hesitate to reach out for me. Email is probably the best method, and we'll put that up on the next screen. I always do my best to respond to everyone within a reasonable time. So, and I believe this link will be emailed out to everyone after this, after we hang up. So until next time, take care, let's be in touch, and don't hesitate to reach out. Thank you very much for having me.